Okay, this is case number 2175, TNV Associates, Inc., doing business as Downriver Crest Catering versus Elizabeth Hertel in her official capacity as Director of the Department of Health and Human Services. Counsel, would you state your appearances for the record?
Good morning, Your Honor. Sean Kelly on behalf of the plaintiff, TNV Associates.
And good morning, Darren Fowler, Assistant Attorney General on behalf of Director Hertel.
This is the defendant's motion for summary disposition under MCR 2116C8. I would indicate, counsel, that we do have a court reporter. She will likely be silent, but if at any point in time she cannot hear or understand what is being said, she's going to let us know immediately. If at any point in time, as things are wont to happen, someone has technical difficulties, we will stop the hearing until we're able to get back in on the same internet and able to hear and hopefully see each other. With that, would the defendant please proceed?
Thank you, Judge, and good morning, Mr. Kelly. Since the time when the defendant filed summary disposition brief in this case, the coronavirus pandemic has moved from being not just the worst epidemic in our lifetimes, but the worst in American history, surpassing the Spanish flu in terms of the death count that we have experienced. To date, we have lost more than 700,000 of our fellow Americans. More than 20,000 of them are Michiganians. So this pandemic has caused a great deal of distress for the people of Michigan and also for the businesses of Michigan, including and especially food service establishments and other places where people used to safely gather. The pandemic has also had a very unfortunate impact on us as a society. We have more of a division in terms of how we approach this than we ever used to. There has been and continues to be a disagreement about how to mitigate coronavirus versus returning to our normal lives. The complaint brought in this case, Judge, demonstrates that kind of disagreement that exists. It is very much a lawsuit built to articulate a disagreement rather than stating a cause of action for a court of law upon which a claim, upon which relief can be granted. The plaintiff in this case is a catering business. It brought its complaint challenging the restrictions on indoor dining that were in place back at the time the lawsuit was filed, but have since been rescinded. Specifically, the plaintiff catering business challenges the indoor dining restriction where there was a limitation on 50% indoor dining. The plaintiff did not include anything in its complaint saying whether it had indoor dining as a component of its business. That restriction on indoor dining expired in Michigan back on June 22nd. The plaintiff in this case, the catering business, challenges the curfew restrictions that were in place. The fact that food service establishments that had indoor dining were required to be closed from 11 p.m. to 4 a.m. The plaintiff in this case did not plead that it had allowed indoor dining, and it certainly did not plead anything about its hours of operation. The restrictions in terms of timing on indoor dining expired back on June 1st. The claims that the plaintiff attempts to articulate in its complaint were not structured in such a way as to show that it has any interest in challenging what it is trying to, the restrictions on indoor dining and these hours of operation. Those are basic pleading requirements. The failure to meet should not be excused. The plaintiff has argued in its brief that it did not include any information about its hours of operation or whether it even allowed indoor dining because it feared reprisal in making those facts known. that assertion, Judge, simply doesn't warrant excusing the failure to plead basic facts. The complaint in this case should not, the plaintiff should not be given leave to amend the complaint in this case to cure these defects as it asks in its response brief. That, Judge, is for the very simple reason that this case is now moot. The plaintiff is seeking only prospective injunctive relief, but these restrictions have not been in place in many, many months in Michigan now. There has been a seismic shift in the approach to the mitigation efforts in this pandemic, and everyone in the state sees and feels it now on a daily basis. We all remember the time when there were restrictions on indoor dining. We remember the time when there were the curfew hours, but we know that those don't exist anymore. For the plaintiff to amend this lawsuit now to retroactively challenge limitations that simply no longer exist would not be an efficient use of this court's resources, and it's not supported by the case law making clear that the plaintiff's threshold is something higher. As Judge Friedman in the Martinko decision that we've attached to our brief in support of our summary disposition motion articulated, any notion that restrictions that have been removed in the context of this pandemic like this, any notion that those would return is, quote, pure speculation, end quote. And that kind of pure speculation, Judge, is just simply not the proper subject of the litigation. So we ask that the motion or the request to amend be denied. Judge, we have taken time to brief the substantive issues of due process and non-delegation within our brief. I will not utilize this court's time to repeat those arguments that we have made in our briefing. What I will highlight is that many of the cases that the plaintiff cites in its response brief do not support the rebuttal it purports to make. To give one salient example is the Eighth Circuit's opinion in Gallagher versus City of Clayton that is cited by plaintiff for the very basic proposition that fundamental rights are protected by the Constitution. What plaintiff ignores in trying to utilize that case in some helpful way is that reading the opinion demonstrates that in the context of that case, much like the case here, no fundamental rights were involved. In that case, Gallagher, the Eighth Circuit, was dealing with a contention by a plaintiff to restrictions that the city of Clayton had put on outdoor smoking. And in the context of that case, the plaintiff there was trying to do something very much like what the plaintiff in this case here today is trying to do, to challenge the science. The plaintiff in Clayton was attacking a city's position that was built on a Surgeon General report indicating that any exposure to secondhand smoke is dangerous. The plaintiff wanted to contest the science. The plaintiff wanted to point out that there were other causes of health problems and lung disease via air pollution that were not being addressed, like barbecues, much like the plaintiff here today wants to point to other causes of disease like pneumonia and say something is going wrong. The Gallagher court invoked the same kind of analysis that the Sixth Circuit applied in the fitness trainer's case in the context of this pandemic, pointing out that the threshold for supporting public health decisions, whether it's to protect people from the negative effects of smoking or the very dangerous consequences of COVID-19, the threshold for public health officials is a low bar, any conceivable basis to support those actions. The federal court in Gallagher nor the court here are not a proper forum to litigate the science or for plaintiffs to bring forward its contentions, however sincere, about the proper way to mitigate the virus. And especially that is true since all we would be doing now is looking in the rearview mirror and litigating about things that are no longer in existence here in Michigan. Judge, thank you.
Hey, Counsel, on page 6 of your colleague's brief, it reads, plaintiff states herein that it is a banquet hall that has suffered from defendants' indoor capacity orders and curfews because it normally serves hundreds of people daily and is regularly open after 11 o'clock p.m. While I do understand your argument about whether or not this is moot, would you not agree that those are factual responses to your question about the plaintiff failing to tell us that they in fact have suffered injury, that they did serve indoors, and that they would have normally opened after 11?
I agree they are factual responses, Judge. They are offered in the context of argument in a brief as opposed to in the pleading as was required. And I note that in Gallagher, the federal court in that context rejected the notion that a pleading defect could be cured by argument in a brief.
Certainly it can't, but in Michigan, we are told under C8 that when it is possible, we are to freely give leave to amend. So as relates to the facts, we understand this is not a pleading, but we would find that this plaintiff, at the very least, can plead facts that, if proven, could support relief absent the other issues of which you addressed.
Agreed, Judge. And our contention is simply that it would be futile to grant that leave in the context of this case, since the amended pleading would still be one to challenge restrictions that are no longer in place.
Otherwise known as mootness, but go right ahead.
Yes, absolutely.
In response, sir. On behalf of the plaintiff.
Thank you, Your Honor. First, obviously, we want to rely on our briefs. I think this has been briefed quite well, rather thoroughly. First, my client is not rejecting the science, quote unquote, but rather the partial picture of the science, quote unquote, which has been carefully selected by the state to serve as a vehicle for the state, Director Hertel in particular, in this instance, though the governor previously, to engage in what my client believes is overarching enforcement. The defendant keeps citing the death toll, but the COVID-19 death toll, like we mentioned, is a little worse than pneumonia. The statistics are clear on that. Those are pulled from the Michigan Department of Community Health's own website. Again, they're statistically identical when you look at the percentage of overall deaths in the state, 0.1% on both sides. And then as a total of all deaths in the state of Michigan in 2020 is 9% for pneumonia and 10% for COVID-19. I guess the nature of the arbitrary and capricious argument centers around where were all of the draconian regulations regarding pneumonia, for instance, to prevent the spread of pneumonia. As Ben Franklin once said, and I think this is really on point here. Those who would give up liberty for a little bit of safety deserve neither liberty nor safety. We've reached an area where the state and Director Hertel herself is citing her own orders as authority. So it's an issue where we have the executive branch citing itself as authority in order to evade judicial review and subvert the checks and balances here, Judge. It's sort of trying to take away the judicial branch's authority here. Oh, don't look at the man behind the mirror. There's nothing to see here. I think that should be concerning to everyone, particularly the judiciary. And I think it should be concerning to members of the executive branch, particularly those people who are appointed cabinet members, such as Director Hertel. Where are we going? What are we doing here? I know it seems like a benevolent purpose, but does it trump the purposes of freedom here? The fundamental rights, which we believe are quite clear in this case. And so I'll more arguments at oral argument here with respect to standing. Paragraph 1 of our complaint establishes that that the plaintiff is a food service establishment located in Rochester Hills. Paragraph 20 states that the business has been strangled by the regulations. Paragraph 23 states that.
Okay, counsel, I'll tell you, I can save you an awful lot of trouble here. As pled, this complaint does not establish your standing. As I said to your colleague, the additional facts that you assert in your brief, if they were subject to a motion to amend, would in fact plead the actual facts of having that you were covered by this ordinance, by this order, that in fact your client ordinarily operated past the hours of the curfew, etc.
Understood. So I mean, if we're stuck there, then I'd like to move for a motion to amend here, because I mean, under MCR 2.116 I5, as you know, Judge, we should be allowed to amend as a result of that.
Well, that's one of the bases on which you would be allowed to amend if it is not, as your colleague said, moot.
Okay, so, and then that segues perfectly, the mootness argument. And it's interesting that defense counsel mentioned our sort of erroneous reliance on Gallagher in another part of this issue, but, or not necessarily mootness, but another part of the brief, because I think that both Martinko versus Whitmer and Hartman versus Acton, which are two cases upon which the defendant relies, were completely in opposite to their arguments. First off, Martinko versus Whitmer, which was decided in June of 2020, only a few months. I mean, this was all new at that point in time, obviously, only a few months into the lockdown. You know, Judge Friedman there said that plaintiff's arguments were, as defense counsel pointed out, quote unquote, pure speculation at that point as to whether or not these orders were capable of repetition and evading review. We know now that that's not the case. All right, we're a year and some change into this, and we know that that's absolutely not the case. And in fact, in Hartman versus Acton, the court speaks to the fact that, and in fact, the court found that the plaintiff's cause of action was not moot, specifically because these sort of orders are capable of repetition and evading review. And in fact, it's Kingdomware it's Kingdomware Tex Inc., versus United States. It's a 2016 United States Supreme Court case that establishes that, and it's cited in Hartman versus Acton, that conduct of a duration less than 2 years necessarily evades review. And then, of course, we have the voluntary cessation exemption as well, which says that, you know, if the actor here, the defendant, Elizabeth Hertel, voluntarily stops the behavior, then of course that operates as an exemption to the mootness doctrine as well. And then, of course, Hernandez versus Consumer Power, which is a 1974 Michigan Court of Appeals case, which talks about the constitutional questions of public import, which I think are clearly prevalent here, are not moot as a matter of law. I know that the due process arguments are pretty well briefed in here, and defense counsel didn't go over them. I don't know if you'd like me to, Judge.
You make the decision on what you think is in your client's best interest. I'm telling you, I have read it, may or may not help, but you make that decision. The fact that you don't address something in oral argument does not mean that you have abandoned it, certainly.
Understood. Thank you, Judge. I guess just to conclude then, I mean, I want to leave the court with a few thoughts here. COVID-19 has a 99.6% survivability rate. And again, the death percentages between COVID-19 and some other respiratory communicable diseases that spread in the same fashion are nearly identical. And those other respiratory diseases have never been subject to the kind of regulations that we've seen with COVID-19. And realizing that the 99.6% survivability rate those deaths are attributed most of the time to some kind of comorbidity and advanced age as well. So, we've got all kinds of science out there. Don't wear masks. Now we are wearing masks. 6 feet apart, no, 3 feet apart. Masks don't prevent the spread. Masks do prevent the spread. Vague justifications based on ever-changing science inexorably generate regulations, which by their very nature, because of the ever-shifting scientific foundations, must be arbitrary and capricious.
Counsel, isn't it the very nature of science that it changes and develops, we hope?
That's exactly the argument that we make, Judge, is that shooting from the hip and closing down across
That
the
was
board.
not, I did not make that argument. I said, doesn't science constantly change and evolve? And if the
Absolutely.
nature of science is to change and evolve, based upon your assertion, at any point in time, any regulation based upon that evolving science is infirm.
Not necessarily, Judge. What I'm saying is that we need to be very careful with how we tailor regulations based on science that we know is rapidly changing because it's new. For instance, the law of gravity, right? We all understand that's pretty well set in stone, okay? COVID-19 is not that, obviously. It's the exact opposite of it. It's new, it's amorphous, it's ever changing. We're not sure. And so the government is required, at least with respect to fundamental rights like property rights at issue in this case, to act with a certain prudence in how they rely upon science and then promulgate regulations based thereon. That's all we're saying, is that because it's so rapidly changing, we need to be very, very careful. The state wasn't and hasn't been here. They shot from the hip.
I understand your perspective.
Thank you, Your Honor.
Is there something you had wanted to, is there anything else you want to leave me with to ponder?
I think I'm good, Judge. Thank you.
Thank you. Anything finally, sir, on behalf of the move-out?
Very briefly, Judge, the problem with the plaintiff's analysis there is that anytime the state is confronted with a new and unknown threat through the prospect of an epidemic, the plaintiff's argument is that the state has to sit on its hands and watch people die until it understands the science enough to regulate it to plaintiff's threshold. That's not the threshold that the Public Health Code, the Constitution of Michigan, or the people of this state meaningfully want. This concept about comparing death counts in pneumonia to coronavirus is an illusion. Plaintiff is pointing to death numbers from 2020 and not even taking account of the fact that pneumonia was present for the full year in Michigan. Coronavirus did not first even emerge until March of 2020. So you can't compare the two numbers on a year basis and conclude anything. Beyond that, pneumonia is an umbrella term for a broad range of diseases, some of which are transmissible, some of which are less so. As compared,
Well, if ever there is a group of diseases that intrigue and befuddle science, it has been those that are respiratory. At one point, this was called the consumption. Then they decided that there were several other diseases, including pneumonias, viral and otherwise. And the treatment for each of those has been different, including at one point, isolation and almost voluntary incarceration, I would call it, for tuberculosis. People were sentenced to sanatoriums. But I will tell you, gentlemen, that as intrigued as I am by the concept of the science behind this, the issue is not for me to decide what's good science, which is why, of course, I went to law school and did not become a bioethicist or doctor, but to determine whether or not these actions by the state of Michigan were in some way arbitrary and capricious or far overreaching. And I will address that. My intent is to do this within 14 days of today. Thank you very much. Well, actually, within 14 days of getting the transcript. And we know that Ms. Robertson is speedy as she can be, but that probably adds another 10 days.
Judge, thank you very much for your time and attention this morning. We appreciate it.
Yes, very much,
you.
Judge. Thank you so much for the opportunity.
Be in recess.
Thank you.